Assalamualaikum and good morning everyone. So I hope you are ready to start off a new week and a new chapter. So for some of you who have gone back to your hometown, Sunday wouldn't be the start of a new week, but since you are still studying in UTM, so Sunday is still the first day of the week. Okay, let's move on. So our second last chapter in this course is on intellectual property. I'm not sure how many of you have heard about intellectual property. So hopefully after this chapter, after this week, everyone is more aware of this topic and its impact on our everyday life. So let's begin. Now, basically, intellectual property, or the short name is IP. Basically, when we talk about IP, it refers to the creation of the mind, because it basically comprises of principles and lots of documentation, and this is to ensure, an IP basically is to ensure protection to an inventor from breach of use. This is more or less so that they could gain something and they could also get protection at the same time. So the protection is actually backed by laws and observed in various forms, as we will see in a while. And even though there are a lot of types of IP, so there are only 4 main types which I'm putting in this course and in your notes. There are a whole lot more, and it depends from one country to another and sectors or industries as well. So the 4 main types that we are going to take a look at is copyright, trademark, patent, and design. Patent is not to be confused with pattern. Okay. Alright, so all these 4 types are basically divided into 2 categories. First, industrial property, and the second one is copyright, even though copyright is actually one of the main types. So in terms of industrial property, it includes patent, trademarks, design, plans, topographies of circuits, undisclosed information, traditional knowledge, and geographical indications of source. So these are all different types of other IP as well. And in terms of copyright, it is usually for materials of literary, written down, and artistic work and broadcasting. So all the films, all the music, they are copyrighted. So IP, of course, is advantageous. And the advantage is basically more to the owner to provide control and reward for innovation, as well as protection. And in IP, we have intellectual property rights, which is the rights given to the individuals, which is the owner or the inventor, over the creation of their innovations, with, of course, certain conditions, which means that it is actually a win-win situation, but with a bit of a compromise. So IPR, or the rights, usually add value for commodities, especially for businesses and for arts, results, and also activities. So it is also vital to balance between interests among the society with rights. So let's go into the first one, which is copyright. So copyright is actually mostly applies to a lot of people. I'm not sure whether you notice this or not. You see copyright, or the more or less the symbol is this C enclosed with a circle. Doesn't really matter what the color is. Okay, but if you see this symbol, it means that the material is copyrighted. Have you guys seen this? So if you look closely, if you have a book, whether a textbook or a novel, go have a look at the front page. Okay? At the author's name or the publisher's name, they would have this symbol. So that means that it is copyrighted. What does this symbol mean, and what is the protection offered? Okay, we will see in a while. So copyright basically is defined as any work that result in independent creative effort and not copied from previous work, which is, of course, okay, should be original. So only the original can be more or less copyrighted. So we will see whether you need to register for copyright or not. So in Malaysia we have, the law. According to the Copyright Act 1987, copyright is defined as exclusive right provided by the law to owners of copyright works to control their work for a specific period. So keyword here is specific period. So something created that is similar to existing work without copying any part of it directly or indirectly may also be considered as original copyright, which means that you revive something, okay? But okay, it could still be copyrighted, provided that you do not copy any part of it directly or indirectly, okay? a modification of the word, okay, modification of the story, okay, could be done. But okay, the extent of the originality can only be decided by the court. You do not have the final say. They will have the final say to determine whether it is different from the original or not. Now, for a qualified protection under copyright, it has to have sufficient work to make the work original in character. How do they do that and know that? They have a board. They have basically people who are certified for this. The work has been written down, recorded, or reduced to material form. Simply said, it has to be either in black or white or recorded, okay, such as what I'm doing now. So the author is qualified for the country he or she applied to, or the work which is first published, okay, in the country. It doesn't really matter. So because sometimes some people just more or less when they produce something, when it is more or less being published, okay, it is copyrighted probably in the country. But if they want to make it worldwide, they want to protect themselves further, they could basically register it for worldwide protection. How? Okay, we will see in a while as well. So these are some of the work eligible for protection. So literary work, like I said just now, musical, either music or probably when you are searching for something in YouTube, did you notice that there are certain movies that you couldn't find or certain songs that you couldn't find as well, okay, in YouTube because they are protected by copyright. So that's why, okay, you can find it. Okay, those are literary, musical, and artistic work that is under copyright. Next, films, the same thing again that what I was saying earlier on, which include music videos and karaoke recordings, sound recordings, including this video that I'm making, broadcasting, definitely, such as news broadcasting or any broadcast, published editions, definitely, because it is in black and white, work of government bodies and international bodies, yes, they are under copyright protection, and some anonymous publications. So if you do not want, or if you are shy, or if you have too much money, you can put, okay, your publication under anonymous. That could also be done. Right, so copyright subsists during the life of the author. So that means that you have the protection of copyright as long as you live, plus 50 years after his or her death, after, okay, your death, following the year in which the work was first published. So copyright provides original creators and the heir protection of their work. So that means that after some creators have died, so they are protected for another 50 years. So who get any royalties, if there is any? That would be the heir if they claim it. Okay, if not, then we will see who it will fall into. Now, isn't it like very good? Okay, you create something, you write a novel, you write a material which is basically beneficial, and you get some benefit out of it, copyrighted, and even 50 years after your death. So imagine that. So the use or authorized use of the work of the copyrighted material depends on them, as they hold the exclusive right, and the basically authorization is up to the author, especially if they register it. So this is among them reproduction of the work in any material. This is an example that would give you is Harry Potter. I'm sure some of you, I'm not sure if all of you, okay, do read Harry Potter books, or you do watch the movie. So reproduction of the work in any material. It was originally written as a book by J.K. Rowling, so it has been produced or reproduced as a movie, and also has been published, okay, in different languages. So those are reproduction of the work in any material. So J.K. Rowling basically determines that, allows that, and whatnot. So public exposure, second, by communication or performance, show or play, such as another example I'm going to give you is also on Harry Potter, because now they have a musical being played in London, so by copyrighted. Third, recording, including photocopying. So this is an interesting aspect, okay? So I would just like, of course you couldn't answer me, but you could just comment down in the video, in the comment, okay, from this video. Have you guys ever photocopy? Don't tell me you haven't, or you have never in your life. That is BS, because I know you have. Even I've done it during my studying time. So any photocopying of a book, okay, from the textbook or any kind of book, those are basically very wrong, and you could basically have a serious complication, or there is probably a lawsuit following you. So you need to be very careful, okay, about photocopying. in the future. And the next one is broadcasting in any form for distribution. And the second last is translation for distribution, such as the example I've given early on is on Harry Potter books, which has been translated into different languages all over the world. And the last one is on commercially rent the work to the public. So you could do that as well. An example that we give you of commercially rent the work to the public is lots of musicals. Okay? Now, in terms of ownership, if there are more than one authors, the first owners are always the authors. For example, literary work, the writers. How, if there are more than one writers, who will be the first one or how they are going to distribute that, it actually depends on them. Work during employment, of course, your employer, regardless. Usually they would have a non-disclosure agreement with you. Government work, definitely the government. Pseudonym or anonymous, usually it's the publisher, unless you state that you want to have the benefit of it. But most of the time, anonymous work is actually the publisher. That means that you release your rights of it. And the last one is unpublished work with no identity of author. If they by chance couldn't find any identity of the author, couldn't trace it back, so usually the owner is the minister in charge of culture. For example, if they found a book which is actually without an author and they want to publish it because they found that it's actually very good, very entertaining, so Minister of basically Trade, or not say trade, sorry, Minister of Culture, usually probably it would be the one responsible for it, or could be the first owner. Alright, now the creators, regardless of what kind of work that they publish, may sell their rights or the work in return of payment called royalties, such as in the case of J.K. Rowling and a lot of other authors for books, novels, and so forth. And some copyright work are actually transferable, such as assignment, testamentary disposition, and operations of law, with, of course, an agreement. Now, the agreement, if it is to be transferred, may specify the exclusive rights. So they would more or less detail out, okay, what they are, period of transfer, area of rights, and number to be reproduced. They even control that. So the economic rights, and more or less this is what the agreement is called as an economic rights, or referred to as economic rights. They provide a time limit of about 50 years after the creator's death and may depend on the country's law. So of course it will cease upon expiry of protection period, and then anyone can claim it. So the right to claim authorship of work and oppose changes gives the creator moral rights. So it remains for eternity, and of course heirs can exercise it. So this would protect them, okay, both the author and the heirs, from misrepresentation of author, distortion, mutilation, and modification of the work. So one of the example I'm just going to give you, okay, on this slide is, have you guys ever seen the Lord of the Rings series, the movies? Or anyone has ever read the books, even the Hobbits? So it is actually from the creator of Tolkien, J.R.R. Tolkien, and Tolkien is actually dead, I think in 1973 if I'm not wrong. It was before I was born. And so 1973 up until now, how many years is it? It hasn't passed 50 years, right? So his heir basically controls the right to reproduce it into a movie. So when the movie was made, again, the royalties goes to the heir. But I actually could remember this. I read this somewhere in 2 years ago, but I think it was early on. The heir basically released the right to the publisher, and the publisher actually released the right to some movie production. So that's why The Hobbit, again, now is not, if any royalties is obtained, it's not being given to the heirs because he has released the rights. So, but again, more or less, again, he or she again has made sure again that again it doesn't misrepresent the author from or distortion or mutilation or modification of the work. So everything remains the same, just that they release the name. So, as owner of the copyright, the creator has the right to enforce in the law and of course administratively. And copyright protection gives creators recognition and reward for human creativity, which of course can enhance innovation, which possibly would motivate you to write more or to create more innovation. So as soon as it exists, a work is protected by copyright. But for some countries, okay, they have an administrative office or law for copyright registration. A lot of countries actually have it now because it's quite hard to monitor if this is basically applies as soon as it exists. Okay, so usually non-authors are also aware of intellectual property, so they usually register it either in their countries or for worldwide protection. So someone who wants to use the work can contact the owner or the heir in terms of, for example, the Lord of the Rings trilogy early on. But okay, it is also permitted to use limited portion of the work as long as it doesn't misrepresent, it doesn't distort, it doesn't basically deviate from the original work. So I'm just going to end the copyright with just that, and you can see that this is among the symbols. In some countries they have different symbols and whatnot. So copyright in movies, if you were, I'm not sure whether you do that, if sometimes after you watch a movie or after you watch a drama series, you just wait until the end for the next series and whatnot, you will see that it has copyright, all rights reserved. Those are usually quite common phrase for movie. Okay, so and among them, usually you can see a lot of variation. This kind of C or this kind of C, or sometimes with different color. But C enclosed with a circle is a symbol for copyright. If you see that, be very careful if you want to copy anything. In Malaysia, probably the law is not that strict. But if you were to go to other countries, for example, when I was in UK, it is actually very wrong to photocopy. You could be basically have a lawsuit following you. So don't do that. Practice it from now. Right? So let's move on to the next video.